Thank you. Apologies. We lost power there. Thank you. All right, so we have member Seleko online. Do we have member van der Westhuizen as yet?
I don't see member van der Westhuizen, but member Nkonlo, member Seleko, and member Brankes are in.
All right. Okay, well, for the sake of time, I think we can kick off. I know that he is in another engagement currently, and I'm sure he'll join us as soon as possible. And I'm very glad our sign language team have also joined us. Welcome. So good morning, everybody. It's fantastic to have you here for our negotiating mandate, where we will focus on the copyright as well as the performance protection bills. I'd like to welcome the members who've joined us and also to those industry stakeholders and members of the media, as well as interested members of the public who've joined us online too. Before we get started, I would like to just run through some house rules. So as per usual, should you have any questions, please use the raise hand function, and also you can turn on your video when you have a question and when you are called on to speak. Throughout the duration of the call, if you can kindly keep yourself muted, and if you can also keep your video off, that'll just make sure that the proceedings run as smoothly as possible. It would also be really helpful if you are in a particularly noisy environment, if you could use headphones, and just make sure that the environment around you is a bit more quiet as well, if possible. So with that, I'd like to give members an opportunity to introduce themselves. I myself am the chairperson, Kayla Murray. Members, over to you.
Hi, good morning, Chair Khalil Brankes, member of this committee.
Morning, member.
Good morning, Chair.
Good morning, Chairperson. My name is Naomi Nkonlo. I'm a member of the committee. Thank you.
Morning, member.
Good morning, Chair. Good morning, honorable members, and good morning, everyone. Mulelo Isaac Seleko, member of the committee. Good morning.
Good morning, member. I still don't see member van der Westhuizen, but I think in that case we can still move on. So the next portion of our program is to consider the matrix of submissions with the DTIC's responses. Can I get an indication, Zahida, will you be flighting it, or Lizette possibly, will you be flighting it?
Chair, I'll be flighting it so long. Please give me a second just to get it up.
No problem. Members, I'd like to put it to you. We have, of course, gone through a lot of the feedback in great detail when we did the deliberation. Welcome, member van der Westhuizen. I know you're online. And so I'd like to suggest that we go through the DTI's responses in sections of 20 pages each. Would you be happy with that?
Okay. Yes,
In order, Chair.
Thank you. All right, so essentially that will mean that we can slowly go through each page just to refresh your minds if you don't have it at hand. And then after we have gone through those 20 pages, then we can use, of course, our raise hand function and indicate our comments or anything that we'd like to flag in relation to what had been raised. Okay, thank you, Zahida. I can see that flighted now. Members, are you able to see that clearly?
Yes, we can.
Okay, thank you. All right, Zahida. Member van der Westhuizen, I see your hand.
Yes, thank you, Chair. I'm just asking for indulgence. We have so many papers in front of us, and I would love
Apologies,
to follow
member.
that.
I'm not sure if it's just me, but I'm struggling to hear you.
I say we've got so many papers in front of us. If you could just allow us a little bit of time, because I would love to work from the hard copy. Thank you.
Yes, no problem. Member, we indicated just before you connected or were able to connect that we would take it on 20 by 20 pages each. and then provide our comments and feedback after those 20 pages. So we can just slowly scroll through those 20 pages, and then we can open up. Okay. Over to you, Sahida. Sahida, if you could just scroll through the first 20 pages. I note it's 89 pages, so for the last 60 to 89, you can just do that in its entirety. Okay, thank you. Members, I'm going to open up now to any feedback that you might have on this first section. If you could kindly raise your hands.
Chair.
Member van der Steesen?
Yes, I'm sorry, but I'm a little bit at a loss currently because I can't get this copy, and I am working with a headlight due to load shedding until 10 o'clock this morning. Perhaps if you could just indicate up to what clause that is, because I'm actually sitting with the bill in front of me and my notes were made on the bill.
Okay, I understand. So can we just mute?
I look forward to that invite.
Apologies. All right, members, perhaps we can do it this way. Given that the clauses aren't as clear in the matrix as they are in perhaps the work that we've done on our own, why do we not instead table this report in its entirety and then provide our feedback on it? Would that be in order? Might make it a bit easier for everyone.
Yes,
and then
thank
we
you so
can.
much.
Okay, thank you. And then perhaps we can firstly look at. Great. Okay. Then we can perhaps firstly look at CAB and then performance protection, just to make it a bit easier.
Thank you,
Member
Chair.
van der Steesen.
Yes, if I may proceed.
Yes.
Chair, perhaps if you would allow me just to raise some of my concerns from the onset, in line with the feedback that we've received from the public participation process. I think the one thing that we cannot ignore is that there was a very high volume of public input, a lot of interest, and unfortunately, the input that we've received raised a lot of concerns about the current drafting of the Copyright Amendment Bill. Comments which I believe we cannot just ignore, and some of them are quite serious. For example, I would love to have more clarity, and I do see that in the comment of the department that was just flighted, that they say, for example, that the legislation that refers to Indigenous communities and the royalties that Indigenous communities should receive is an act of Parliament. The problem is, for me, however, that it has still not been signed off by the President, and it could very well be referred back to Parliament by the President. So to now build in terms of legislation onto another piece of proposed legislation, which has not yet been promulgated, is for me problematic, and you will see that the words Indigenous communities appear quite often in the Copyright Amendment Bill. Secondly, Chair, I am concerned about the prescriptive nature of the Copyright Amendment Bill when it says, for example, that, you know, the minister may prescribe royalties. Now, even though the minister must publish this for comment, etc., it does, in my mind, open up the door for the minister to have only, can I call it, 1% of royalties. Whereas I believe the whole issue of copyright is so wide and quite often royalties must be shared, and sometimes people are not interested in receiving royalties for the next 50 years or something like that, but they want to sell their right to those works, and I honestly believe that we should also allow for that. If an artist is, for example, cash strapped and would love to have a bulk payment being made to him or her for work that he or she has created, then I think that should be allowed for. Also, the terms of the contracts, the agreements that copyright holders must enter into, to have that as a prescribed contract, I think is again too prescriptive. And may I add, I think some of this may not be in line with the freedoms allowed under the Bill of Rights that we have. I also, for example, if you look at, and may I continue in this vein, Chair? Would you give me that leeway?
Yes, I'm happy for you to do so, and then we'll take other members after you. I think this is the most efficient approach.
Yeah, no, thank you very much. Then just, when we look, for example, at the definitions, and you will find that in the first clause, for example, and I'm sitting with the bill in front of me, the printed copy on the bottom of page 2. It says there, for example, an orphan work means a work in which copyright subsists and the owner of a right in that work cannot be identified. Now, just a small insertion, such as the word reasonably be identified, I think would already go a long way to give a bit more surety, because when can how long must I look for somebody? How long must I keep on searching for someone? And how is it possible that people can say, well, the author cannot be identified? As long, I think, in a court of law, if I can prove that I have tried to identify the author of a work, I think that should then stand. But unfortunately, the wording in the document does not provide, for example, for that. If I go, that's on the top of page 4. If I go to clause number 5, the sharing royalties regarding literary or musical works, again, we've had very serious concerns from some big role players in the entertainment industry, regarding this, and asking for a serious amendment to this paragraph 6A. And we must also keep in mind that this is now the copyright amendment bill. There's also the performance bill that also touch on many of these aspects. Then, Chair, if I can continue to illustrate on page 7, section 7B, there it says the author of a visual artistic work in which copyright subsists or their heirs, as may be applicable, must be paid royalties on the commercial resale within the art market of that work. Now, if you read that section, you will see it's very, it works from a certain position, a position where there will be a seller, and there will be an art market professional, and there will be a buyer. And it's not always that the case. So now it says royalties shall be payable at the rate prescribed by the minister. Now, this just is the point that I've made earlier, that it takes away people's freedom to negotiate, and some artists are entitled to ask for more royalties because they are well known, or due to market forces, and this one is now taking away the forces of the free market. If the bill stated, that there are recommended rates, or even if the bill stated that there are minimum rates, which again might be problematic, but now it says it must be the rate in the Gazette that was published by the minister, and that the minister may amend this prescribed rate. It only speaks of one rate, which I really find problematic. And then, as I've said, then the seller and the art market professional concerned are jointly and severally liable to pay the royalties contemplated to the author or their heirs as may be applicable. Now, the seller may also be the author, and I don't really see that being provided for. Then also, Chair, just to highlight, these are just a few aspects which I want to highlight, which I personally find problematic. We've seen, I think it was particularly Professor Dean, as arguments regarding the scrapping of the term cinematograph films, and that being replaced by audiovisual works, and the fact that audiovisual works is the wider term, but that there should be particular provision for cinematograph films as well, which is unfortunately now disappearing from this. I'm moving on, Chair, to section 9, which inserts or wishes to insert a new paragraph 8A. If I go down, for example, to subparagraph 6, any person who intentionally fails to register and act as contemplated in subsection 5A, or who intentionally fails to submit a report, I think it's very difficult to prove whether somebody has what a person's intention has been there. And I personally would love to have seen a redrafting of that. A little bit lower down, 6C speaks about the amounts to be paid, where it starts prescribing fines and so on, and there it says it will be based upon the annual turnover of a convicted person, or if that's not a national person, in the financial year immediately preceding the offence, or the majority of offences under all transactions to which this act applies. Chair, I honestly think it might be problematic to say, well, because my understanding is now we will have to wait before we go to court, because we still don't know what year will this person be transgressing, be guilty to the majority of offences. Now, you're only guilty of an offence, once you're found guilty of an offence. But now we can't base the fine or to calculate the fine yet, because it might be that this person may be on the up in terms of the number of offences. Chair, and so I can go along, and I don't want this to turn into a monologue, but as you will see, I'm concerned that, in terms of what we have in front of us, that it is just too prescriptive, that it unfortunately may violate some of the rights under our Constitution, section dealing with the Bill of Rights. And as I've said in our previous meeting, I have the clear picture in my mind that if the different parties, those that drafted this amendment bill, and those that are concerned and those that involved themselves in the public participation processes, if they could just engage one additional round serious roundtable talks, that we would have had a product where we would not be in a position, as I fear we currently may be, where this piece of legislation may be taken to court, may be challenged, or either where the president might refer it back, as the president has done before. When we warned before about the drafting, some of the clauses, etc., it was ignored. And the president then eventually, in his comment when he referred it back to Parliament, actually reiterated and confirmed those positions. And I am of the opinion that we again are putting the president in a very, very difficult situation with this piece of legislation that we want the president to sign off on. And therefore, Chair, I would like to propose that in terms of our negotiating mandate to our representatives in the NCOP, that we actually recommend to them to say this should be referred back in its entirety for redrafting, for addressing the problematic areas, some of whom I hope I've highlighted, and that we do not support the adoption of this piece of legislation. Thank you, Chair. Let me first stop there.
Thank you very much, members. So members, just to go back to the program. So we were looking at the deliberations on the stance to be taken on the negotiating mandate, but I do note Member van der Westhuizen has put forward a position which we were previously looking at consideration of the matrix rather than deliberation on the stance. But I do note that a stance has been put forward. So perhaps because we have tabled the matrix in its entirety, that we can also put forward deliberations on the stance. Members, are there any further inputs with regards to the copyright amendment bill? I recognize Member Nkondlo.
Madam Chair, thank you for the opportunity. Chair, I'm gonna follow suit because I'm not gonna follow the matrix. I'm gonna just share my general comments on both the bills, with the intention, obviously, to get to that point at as per your guidance when we suggest what should be the stance. I think first and foremost, Chair, I think all of us should consider that the absence of clarity around copyright and intellectual property continues to actually present the knowledge space, the very production of such at a serious disadvantage, because where there is legal and policy uncertainty, particularly for those that are not necessarily protected in terms of their own establishments, in terms of their own development of their works, in this context being it your artists and others that are producing knowledge, which may have legal powers, which may have legal machinery, and some kind of development from their side that enables them to sort of identify areas from which they could be exploited in their interaction with others and trade of their works. And this has been a practice in South Africa for donkey years during the apartheid era, right up to date, which actually makes these two pieces of legislation very critical in the context of redress in that same constitution that we are referring to, of ensuring that people, their socio-economic rights are protected. So I think the spirit in which we should, as the committee, discuss this is to take into cognizance that as we sit today in the absence of clarity, and if we still are sitting with old legislation that are enabling the exploitation of those that depend on this particular protection, we ourselves are actually placing under further exploitation. And because of that, Chair, and taking also the submissions that have been made, and indeed, I want to follow a member Andrikas to sort of appreciate the kind of that we received as this committee and the interest that was demonstrated from young people, in particular indigenous groups, academics, artists themselves. I think that we should comment, including those that are not even in the province having an interest on them. And because of that, Chair, I think we should emphasize that we can't keep on delaying this particular process. That, for me, I think it's something that we need to underscore. That if we continue to delay this on the basis of the, you see, that for me, I think would be a serious challenge. What we ought to do is to exactly point out, as we are doing, as it has been, and request that the department and the national assembly, through our negotiating mandate, forces, I think, the department to heed particularly these pertinent issues that are being raised by callers on the matters that they've raised, because we have received support of many, but with specifics stakeholders are raising. So the intention here, which I think that point to ensure that is finalized, but those particular areas need to be protected. And I would think it is a responsibility that is where has been raised, and I'm going to raise, I think, appreciating the notion of fair use, and I think Panorama, which was raised by Wikipedia South Africa, is an example. But with that said, I think the concerns that have been raised around fair use itself in clause 12, which must be explicitly differentiated between fair use in relation to music composition, authorship, and fair use in relation to academic literary works. So this is one of those issues that I think one would require that such needs to be infected into that clause 12, with a sub-clause that could read, notwithstanding section 12A and section 12D, any use by or for persons benefiting from or engage in primary or secondary education or further in ongoing education, adult literacy and adult education shall be deemed fair use, provided that the use is restricted to literary works or in respect of other categories of works and performances is limited to instances where no license is available within a reasonable time and at a reasonable price. These are some of the propositions that seeks to ensure that fair use doesn't disadvantage, I think, those that would have produced, because part of regulating such production of knowledge would be licensing thereof. So it is important to consider in those particular instances, as I have already indicated. But further, Chair, to ensure that I think the issue one raised in the last engagement with the department, that also the copyright itself includes intellectual property pertaining to scientific and technological inventions or inventors, in addition to the creative and literature sector. Therefore, submit that the formulation of clauses in the Copyright Bill must not hamper or obstruct the exploration and innovation of new ideas by vague and over flexible usage exceptions that could inadvertently expose them to IP infringements. And I think if we also consider that one of the issues, Chair, that you would have raised in the last, I think, is the space that we're in of technology, which, yes, it did. As we speak now, the department spoke about, some studies that have not been done at that point. And I would think that it would be important that the department start to do such studies, because already, if we think today, that technology has has actually taken over. Majority, if we think of young people that would have spoken in the public participation, right from Garden Route, where we were, into West Coast, where to date they are already engaging at the intellectual platforms to share with international production houses their works. And I think that particular protection becomes important to then be tied up, so that the process flow for that is something that is done, because part of, I think, things that are not clear is actually those processes that must then enable the new entrants into the markets themselves. So all I'm saying, Chair, from where I'm sitting, I think it becomes important that we consider that there is space in our current legislation, and the inputs that we are giving as members seeks to ensure that this process that has been taking so many years to date gets to be completed. And if we could, through the process, even make suggestions, of some kind of a time period, because we can't perpetually do this back and forth, because as we do this back and forth, the reality of the matter, in the absence of a clarity on these matters that are very pertinent, we remain with the old legislation that indeed is not helping those that we stand here and say we are protecting. So that is my submission at this point, Chair. Thank you very much.
Thank you very much, Member. Members, are there any further inputs with regards to the Copyright Bill specifically? All right, I don't see any hands, and so I would just like to put a few of my own thoughts forward. So yes, I would like to agree and reiterate the importance or the significance of what the bill aims to do in protecting copyright. And in protecting copyright, we are looking to create jobs and to create opportunities. But my concern from this process, and this has come up time and time again, is that the research which is supposed to underpin this entire legislative process, and this bill in particular, has not followed the necessary processes to ensure that the outcomes of this bill will actually result in greater protection for performers, and that it will create better job opportunities and be enabling. So to that point, I would just like to raise the following in terms of process followed. The industry itself has been trying to engage time and time again with DTI to get an understanding of the social impact assessment or socioeconomic impact assessment conducted in terms of this bill. And we as a committee have requested this information. We firstly requested this at the Stellenbosch hearing, where we received a report which I believe was commissioned in 2011 or 2014. And it is worth noting that this report was commissioned prior to the legislative process actually having taken place. It also didn't provide a social impact assessment, so to speak. So it didn't really look at how fair use would impact on the various stakeholders who would be affected by the change in copyright or by fair use. We, at our last meeting with DTI, were informed that a CS report was introduced into parliamentary process and that the CS report had been completed but had never been shared with the industry, which I find deeply problematic given that so many within this industry had voiced their concern over a lack of a socioeconomic impact assessment having been conducted. My question is, why was that research, if it had been completed, not then shared with the industry who had made this complaint time and time again? So we received the social impact assessment, and having perused it, I can say that this social impact assessment, socioeconomic impact assessment, or CS, that's what they refer to it as, it doesn't look at how fair use in and of itself will impact on various key elements or key stakeholders within this industry. It doesn't consider how fair use will impact on publishers. It doesn't consider how fair use will impact on musicians, on those in film, on those who are in publishing and copyright. And I think that this is extremely problematic because in my reading of the CS report, the report really drills down into what are the intended consequences, what do they believe the benefits will be, but the nitty-gritty and the research into what might happen and what the current situation is with regards to copyright in South Africa, it just isn't there. I also just wanted to add that there has been 6 years worth of inquiry into whether or not a research document of this nature has been provided, and that no regulatory impact assessment on the copyright bill was presented to Cabinet as a part of the Cabinet memorandum to approve the bill when Cabinet approved the bill to be introduced on 8 June 2016. The CS report wasn't even ready when the previous Minister of Trade and Industry, Rob Davies, introduced the bill to Parliament nearly a year later in 2017 in May. There were confusions that could be made as well from a previous official's admission that the report was signed in 25 May 2017. So what is concerning here is that the absence of this document when submitting the bill to Cabinet for approval resulted in a failure to comply with the guidelines that were set out in the social impact assessment, and that would have applied at the time of 2015. And this resulted in a failure, which is also contrary to the earlier practice of supplying regulatory impact assessments with the bill, and breached the undertaking by the Department of Trade and Industry to support stakeholders with a regulatory impact assessment following the drafting of the bill. So I think that these are extremely grave considerations or a grave situation in which the bill presents itself to us. The bottom line is that we really don't know how fair use is going to impact the creative and performing industry in South Africa. With that, I would also just like to flag a few other points from the submission made by DTI in response to the comments received. Firstly, with regards to Wikipedia, the proposal is to support freedom of panorama, which comes under a separate section to the section on fair use. It's worth noting that there are countries such as France, which do allow for freedom of panorama without adopting fair use. So it shouldn't be considered that the two are the same nature. They can both exist in law, or they can exist without one another. I am concerned that a number of submissions, detailed submissions, were made by the likes of Saipel, Professor Kajika, Professor Owen, or Dean Owen, and Mnet, in which the department didn't engage substantially or substantively with the nature of the complaints made, and the complaints or the issues highlighted were incredibly detailed. Then I would also just like to go back to one of the comments made by Research ICT Africa, and I would like to echo my colleague, Member Nkontlo here, that of course we are in a digital age. And for me, it is wholly insufficient for the department to say that they can't make new amendments through this process. This process is essentially about supporting copyright. This is the platform in which members of the public can come forward and make suggestions to create better protections. We are living in the age of blockchain. We are living in the age of AI. And so it is important that we be considering this in the legislation that we have before us. The timelines between these pieces of legislation coming into effect are far too long. And so we're going to really miss out on an opportunity to protect people. I go back to one comment made by Voices of Africa, where they spoke about the need to have a digitized system for recognizing blockchain, or for recognizing, I've got blockchain on the brain now. Their suggestion was ultimately to recognize digitizing systems, to recognize copyright. And this was simply batted away in DTI's response. And their argument was that copyright is recognized automatically, and it's not necessary to have such a system. But you can also argue, and I think this is to the point of Voices of Africa, that having such a piece of equipment to digitize or to provide recognition would help to prevent litigation. It would help to prevent any confusion of who the owner of that particular artwork is. And so I am concerned with the lack of engagement on the very substantive engagements that we have received, or inputs that we have received. Many people have taken a lot of time out to study this incredibly complex legislation, and they deserve the opportunity to be fully engaged with. Members, those are my comments. I don't know if there are any others. Member van der Westhuizen.
Yes, thank you, Chair. I would like to support what you've just said. I think it comes down for me to the following. Many international companies over the last number of years have chosen South Africa, for example, to produce audiovisual works such as films, advertisements that they come to shoot here, etc. And we've been doing quite well, and we've been building quite a good reputation. I think what we want is we want more artists to come to South Africa. We want more work to be created, because as you've indicated, that is a job creator. It's a creator of wealth, and it can lead to prosperity. And so we need a revision of this legislation urgently. I think that's what Honourable Kondlo has also said. But, you know, we don't want change because of change. And I think when we eventually support or pass legislation, we want to be proud of it, to say that this is the best document that will steer and guide, in this case, for example, the creative industry. And unfortunately, due to the aspects raised through the public participation process, it's not as if we are now, coming up with arguments that does not reflect what we've been told to take into consideration. And taking that into consideration, I fear that we cannot just under time pressure say, well, we need to pass this. I know there is the time limit of September this year set by the courts for certain amendments, and it would have been wonderful if, in the redrafting of this, if the aspects highlighted by that court case would have been addressed. But now it seems to me, unfortunately, as if a lot of other changes are also being pushed through to try and meet that deadline. And I think that is a mistake. And I do hope that that mistake can still be rectified. I hate being like a sausage machine where we are now set, kind of have a gun to our heads to say, but the courts have said we need to adopt this by September, and now we must adopt a number of clauses that we still find problematic. Thank you.
Thank you, Member. I recognize Member Nkondlo.
For me, yeah, I really want to emphasize, I think
Member,
the point.
my apologies. Your audio is very poor. I'm not sure if it's just me.
No, this side as well.
Okay.
Are you possibly able to change your network?
No,
Sorry, Chair, we can't hear.
Apologies, Member. We really are struggling to hear you. Perhaps if you could use the chat function. Alternatively, you could also email in the input. I'll just give you a moment.
The sound was so good the first time round. I do hope she's able to rejoin with a better connection.
Yes. All right, we'll just give her one more moment.
you hear me now, sir?
Yes, I can hear you. It's a bit better.
Okay. The point I wanted to emphasize was that we are sitting with the Copyright Act of 1978, which is 45 years old as we speak. That Copyright Act and the has been done to date. The point speaks to the reforms that have been taking place in most other countries around copyright. And I think what, for me, becomes very much important, amongst others, I think we also did hear it by people around how, you know, copyright use is actually distinctly. And these are things that, once again, one emphasized the point that to further delay this, we're keeping out a number of people that are disadvantaged by the current legislative framework that we have. And I want to emphasize that point, that as we make these particular submissions, we that the legislation that about
Member, apologies for starting to lose you again. I lost you at we're starting to emphasize. Okay, thank you, Member. Members, please note that Member Nkondlo will communicate on the chat, and so she will submit her writing shortly. So we'll just give her a moment. But in terms of the process forward, once we've all had our input with regards to the copyright bill, then I would like to suggest that we indicate finally whether the committee confers on the Western Cape's delegation in the NCOP the authority to support or not support the bill. And then members, if I can ask, just to assist our procedural officer, you have provided very substantive and detailed feedback. And so if you could just assist her when she does write her report shortly, by just emailing her through some of the comments that you have made. If you could do so already, that would be very helpful. All right, so we'll just see the response provided. None as yet. But if I could just get an indication so long, if we are happy to go ahead and move on the negotiating mandate thereafter. I recognize Member Seleko's hand.
No, thank you very much, Chair. And before Member Nkondlo disappeared, and she just came back and tried to re-emphasize the fact that we should not delay this particular piece of legislation. And unfortunately, Chair, it is our responsibilities as legislators not to be put under pressure by a process, because ultimately our responsibility is to making sure that the bill that or the law that is going to impact on the person is a law that is just and equitable, and it's a law that will not be contested or litigated, by certain stakeholders. So unfortunately, we have to put the needs of the people, at first, and make sure that whatever bill like is adopted or is supported by the Western Cape Provincial Parliament is a bill that will add justice and make sure that we deal with the imbalances of the past. We can never allow a situation where a bill is supported based on or by virtue of it has been coming for years, and it's going to be delayed by us, raising questions, and by us, saying there are a lot of issues that is unclear, and those are the issues that must be flagged, and those are the issues that must be corrected. And also the issue of public participation is a very important part, and public participation is not a process that must be rushed. The NCOP must do its job, and we are going to tell that's what we are saying to the NCOP in terms of our negotiating mandate, that these are the issues, look at them, and then when we come back, when then we deal with the final, then we can also look at it and see whether they were able to look and attend to our concerns. But Chair, what I'm just trying to say is that unfortunately we can never find ourselves in a situation where we do something for the sake, because we are worried that we are going to be wasting time. Thank you very much, Chair.
Thank you very much, Member. Member, I do see the reply from Member Nkondlo, so I'll just read that aloud. She's written that South African copyright law is far behind, with many countries moved in copyright reforms to consider the developments at a global level and technological advancement. Members, with that, I would now like members to indicate whether the committee confers on the Western Cape's delegation in the NCOP the authority to support or not support the Copyright Amendment Bill with reasons. So members, if you could please raise your hands on this, and I will take your feedback. And if I can also just ask thereafter, if you could submit your feedback in writing to the procedural officer with regards to this and the previous comments. Thank you. I recognize Member van der Westhuizen. So you unmuted yourself briefly.
Yes, thank you, Chair. You asked us to raise our hands. I wish then to propose that we, of the two options put to us, that we do not support this, and that that view be relayed to our representatives in the NCOP.
Thank you very much. I recognize Member Seleko.
Chair, thank you very much for the opportunity. Then I would second the view raised by Member van der Westhuizen.
Thank you. I think I saw Member Nkondlo's hand up.
Chair?
Yes.
Can you hear me, Chairperson?
Yes, I can hear you,
Okay.
Member.
No, thank you. I want to move the committee supports the bill with the submissions of the technical inputs that we have made, and we consider, amongst others, the concern raised by some of the stakeholders, including SATU, with the on the ongoing deals in the process, especially in the first
Member,
version
I'm
of
so
the bill.
sorry. We're starting to lose you again. I see your hand, Member Nkondlo.
We'll still write my input, Chair.
Okay,
I don't know
thank
what's
you
the
very much.
problem.
All right. Okay, in that case, if the members could all email through or write through their feedback to Ms. Adams, that would be extremely helpful. I recognize Member Brinkes.
Oh, no, thank you very much, Chair. Chair, yes, we also would like the Al Jamaa to be noted and recorded in supporting this bill. And we also would like our grievances to be noted in terms of what the stakeholders have brought up, especially in regard to artificial intelligence and how it will be impacted with this bill. But otherwise, yes, we would like to express our minority view to support this bill. Thank you very much, sir.
Thank you very much, Member. All right, members, so we will now move on to do the same process, but instead with the Performance Protection Amendment Bill. So just to go back a step, members, if I could please get an indication of your comments with regards to the Performance Protection Bill, and then from there, we will look at whether or not to confer the delegation to the NCOP on authority, whether to support or not to support. Can I get an indication of hands? I recognize Member Seleko.
Thank you very much, Chair, for the opportunity. Chair, as we all know that the two bills ran concurrently, and some of the issues that has been highlighted, especially one issue that when you talk about the CS report, is also something that came up as a concern during our deliberations and during our public participation and comments, especially from some of the stakeholders, the lack of that particular report. Even though the department tried to explain as to why it was not shared with the public, but it still raised some concerns. Because if you read what the report says, it talks about some of the risk within the industry and how the risk should be mitigated. And I believe that if it was shared with the broader, stakeholders, maybe we could have gotten much better, understanding in terms of the processes. Also, Chair, it's very unfortunate that the bill has been criticized for having been poorly drafted. As some of the information you find in the Copyright Amendment Act is a duplicate in some of the provisions, and that might lead to some confusion, and it could be problematic going forward, Chair. Also, Chair, in terms of the equitable remuneration, there is, in terms of that particular clause, it does not give us many or more specifics at what is meant by equitable remuneration. So when the lack specifics, one might be, using different interpretation of what equitable remuneration is, and so unfortunately, the lack of specifics and guidelines, in that particular clause is also something of concern that needs to be looked at by the department. And Chair, and at this particular time, Chair, I could not get, the department could not, convince me that, in terms of the international treaty, whether this particular bill is going to have a negative or a positive impact, and how does this bill particularly mitigate such, and that is something that the bill does not actually, assist me in making sure that this particular bill, is not going to affect, the performers, especially, from other countries, or whether it complies, with other countries and it's relevant to other countries, or is it just relevant to us as South Africa, and but it's going to disadvantage, our artists when it comes to other countries. That is something that is also not coming through very nicely, Chair. And also, Chair, the definition of a performer, because in the bill also it talks about extras, are also performers. So I don't know what is the view, of the actual actors, because an extra is someone that is just brought in for a particular episode or episodes, but performers are just people that, they live this thing, but in the bill they are regarded as performers. So, Chair, I think that's my little bit of input in this particular regard. Thank you very much.
Thank you very much, Member. Members, are there any other opinions or views with regards to the Performance Protection Amendment Bill? I recognize Member van der Westhuizen.
Yes, thank you, Chair. I think it should also be noted that there's a lot of overlap between the Copyright Amendment Bill and the Performance Protection Amendment Bill. And some of the public comments that we've received was actually to say that the Copyright Amendment Bill should exclude those that sections that deal with the protection of performers or the royalties of performers. So I think that is something to be noted, that we might now be ending up with two pieces of legislation trying to legislate the same kind of work being done. So in that regard, I think we must be careful of that. Then also there's the whole issue of the execution, royalty received for the execution of certain acts. Again, it seems to me as if the words might be improved, the wording might be improved in that regard. So I want to add my voice to that of the Honourable Seleku, to say that based on the large number of submissions in which people have indicated that they cannot support the current wording of the Performance Protection Amendment Bill, that we also cannot support it, and that we also need to refer it back and ask for those real public comments, the real concerns expressed, that be addressed. And Chair, I think referring back to your concerns about the lack of a socio-economic study or the risks, the one thing that we don't want to see is what has exactly been happening in, for example, the mineral work, the mining world, where people take their work away from South Africa. Their investment is now being done in other countries where they find it easier to invest. And I'm really concerned that we will see a situation where we want to grow the economy and grow the performers world and attract more people so that the quality can improve, that we will unfortunately see more and more companies rather investing in other countries where they believe they've got more freedom to negotiate with the artists, etc. So I cannot support this. Thank you, Chair.
Thank you very much, Member. Member, I see your hand just went up again.
Sorry, that wasn't
right.
effort to lower. Sorry.
Okay. Members, are there any further comments with regards to the Performance Protection Amendment Bill? Okay, I see none. I would just like to unpack a little bit more or some thoughts rather, with regards to the lack of a socioeconomic impact assessment or a thorough CS report. So, as I highlighted before, the CS report was supposed to be tabled before Cabinet. And my question is then, what was actually presented in the Cabinet memorandum under the previous minister, Minister Davies, at their 8 June Cabinet meeting? My concern is that there was misleading by the department when they communicated on their website on 12 July 2016, which has since been removed, which announced Cabinet's approval. The media release referred to a forecast of growth in the economy by 5% if the bill was properly implemented. But what is lacking is essentially to know, with regards to the statement, where did this information come from that went to Cabinet? Then I'd also just like to note that if we look at the CS document that was shared with the committee, and that was not shared with industry, it shows that much of the content is rehashed or basically regurgitated in terms of the bill. And from this document, it's not clear that any research was done in compiling it, particularly with regards to fair use. And so it's not clear what the actual value of the socioeconomic impact assessment is. But what is worth noting is that DTI no longer relies on the 2014 report on Genesis Analytics or the 2011 study that they inferred was done by WIPO that was actually done by the University of Pretoria. They referred to the PASA study. SciPol conclusively demonstrated that the Western Cape and to our provincial parliament, that neither document that DTIC or DTI made out in its presentations to the NCOP or provinces were included, and that there was proper research to support this bill. So members, again, I am really, really concerned that there is a lack of research underpinning both the CAB bill and the Performance Protection Bill. And so we do not know what the economic consequences are going to be for performers and for those in the creative industry. It's not enough, in my mind, to have a bill that intends to produce good economic outcomes, but has no empirical evidence that shows that this will be the case. Yes, fair use may be a successful doctrine in the United States, but their socioeconomic environment is very different to our own. And it is worth noting yet again that fair use is not a common doctrine used when it comes to copyright. Fair dealing is far more common, and there's a lot of reason for this. Fair use also leaves a lot of room for ambiguity and vagueness in the law, and fair dealing provides for more clear definitions. And I think this is very important to note within the South African context in particular, because we are not a country that is equal. And as a result of that, not many people have equal access to the courts. This might lend itself to people being taken advantage of if fair use were to be implemented, because with fair use, the only way to get clarity on copyright is to approach the court due to its vagueness, which means that many may be left behind if this provision was to be implemented, unlike fair dealing, which is far more clear within the legislation. So I'd like to leave that there in terms of socioeconomic impact. I do think that this is an underlying point for me as to why this bill should not be accepted and why it needs to be reviewed in its entirety, possibly also with further and deeper research conducted into the actual impact of fair use in our country, in our specific dynamics and socioeconomic situation. With that, I'd like to recognize Member Nkondlo.
Just having listened to colleagues in previous the proper bill itself, we recognize that these two are closely aligned. And I think colleagues follow this work, because we should not make an assumption this work is starting with us. The issues have been ventilated very much. And even in the same vein, colleagues will talk about what are the submissions. We should not create an impression bias, particular should not take in common sense, because if we talk about fairness, we must bring both those concerns and comments made in public. Have only one view on the matter. So I think it is important for us to fair and not listen to one voice. And I raise this because even ourselves, in submissions we're referring to, which are part of the submissions that have been shared with us, Dennis is an expert on the field, particularly including some of the studies around this concept of AU, not the Africa, but even
Apologies, Member, we're starting to lose you again.
It's very resource and my point. Yeah, it's fine. Are you hearing me?
We can hear like every second word. I'm watching the sign language lady interpret you, and I can see she's struggling a little bit as well. So I don't know if you want to try and make the points, and then you can also write it afterwards, or if you would prefer to write. All right, Member Nkondlo, then I note that you have muted yourself, so perhaps we can just allow you to also write your comment. Members, are there any further inputs with regards to performance protection? Okay. Member van der Westhuizen, I see you're unmuted. Did you want to say anything as well?
Chair, I think the one thing that we really need to also relay is that we support the objectives of both these pieces of legislation, but that our concerns are, just too big to really be able to support it at this point in time. But the objectives of these are sound, and as the Honourable Nkondlo has said, a review of this or amendments to this are actually long overdue. So it's a real pity that unfortunately there are still so many, can I call it, problematic areas.
Thank you, Member, and I completely agree. I mean, we've seen a lot of cases in South Africa where a lot of our artists have died hungry. They have not been able to bear the fruits of their hard work, of their labor, of their ingenuity. And we really do need to make sure that we are supporting them. And my argument for that is that we need to make sure that the legislation which purports to do so is actually based on empirical evidence and not on an ideal or a policy which is driven by an ideology. We need to know that it is actually going to empower people as it says it will. So I agree with you in that regard. We'll just give it a moment still for Member Nkondlo to write. I know she's responded saying process instead of, okay, we'll give it a moment for Member Nkondlo to just write her concluding remark. But then from there, once we receive that, members, if you could kindly indicate whether the committee confers on the Western Cape's delegation in the NCOP the authority to support or not support the Performance Protection Amendment Bill, and if you can please provide reasons as well for that. From there, we will also note the minority party views, and members, just again, if you could please, we've had a lot of very detailed and robust engagement this morning, and I appreciate it. Appreciate you all having a very strong cup of coffee before. And so if you could just send through your comments, because they have been so detailed, to Ms. Adams, just so she can record that correctly in the report when we do go through the report. Member Nkondlo, can I just get an indication from you whether you are still writing up your last comment? Okay. All right. I'm not sure if Member Nkondlo can hear us. But what I will do then is, members, is we'll move on. Members, if you can please indicate whether the committee confers on the Western Cape's delegation in the NCOP, the authorities to support or not to support Performance Protection Amendment Bill, and if you can please provide reasons as well. I'll now open up. Kindly indicate using the raise hand function. I recognize Member van der Westhuizen.
Chair, as I've said, I do not support or don't want our representatives in the NCOP to support the Performance Protection Amendment Bill. And the reasons that we've forwarded already, as I've said, despite us being in support of the objectives of the bill, we believe again that it is too prescriptive, and we fear that there are certain risks that have not been ably studied and quantified, and that it may eventually work against the objectives as stated in the bill. Thank you, Chair.
Thank you very much. I recognize Member Seleko.
Yeah, thank you very much once again, Honourable Chair. I concur with the views of Honourable van der Westhuizen, not to support with the reasons, of course, as I have also indicated previously when I spoke on this particular matter, that I've raised my concerns. Thank you very much, Chair.
Thank you very much, Member Seleko. So we have received feedback from Member Seleko as well as Member van der Westhuizen. Members, are there any other views with regards to conferring to the NCOP whether to support or not to support the bill? I recognize Member Seleko's hand went up and down. Right. I
was lowering it, Chair.
Thank you.
Thank you, Mama.
Members, any other inputs on this? Okay, none received. With that, members, I would now like for us, as the discussion has concluded, to afford members, or to afford the procedural officer, rather, some time to draft the negotiating mandate. Member Nkondlo? Member Nkondlo, would you like to come in? Okay. Member Nkondlo, I believe that you would like to make a comment. And so what I would like to suggest then is if you could perhaps write your comment again on the chat, and then we'll note that in terms of your minority view, if that's in order. Alternatively, you can send it in writing to either myself or to the procedural officer, and we'll make sure that that is reflected as well within the report. With that, members, if you could please allow for 30 minutes, we'll take a break. We can have a coffee and a bit of a body break. In that period, our procedural officer will work on the report. It's actually extended a bit longer because we're doing very well for time. We can try and meet back for about 10 o'clock. So with that, we'll now take a break. Thank you, members.
Thank you, Chair.
Thank you, Chair.
Thank you. Just a reminder as well to members to please submit any of your feedback by 10 a.m. absolute latest. We'll now move on to the consideration and adoption of the negotiating mandates. We'll begin with the consideration of the draft negotiating mandate on the Copyright Amendment Bill first. So if we can just flight that, and I will read the draft negotiating mandate on the Copyright Amendment Bill. While we wait for that to be flighted, I'll just speak through the rest of the actions. So once it's been read, members, we can then amend it as necessary. And I'll ask members to indicate whether you would like to adopt the negotiating mandate on the Copyright Bill. And then from there, we'll do the same process, but with the Performance Protection Amendment Bill. Thank you, Lizette. I can see that. Sorry, I'm a bit blind, so if you can just make that a bit bigger. My eyesight's not so great. Okay, thank you. All right, members, I'm going to now read the report. Before I start reading, there are a lot of clauses that are quite long in this. So if you'll indulge me, I will just reference the clause and then move on to the next section so that we don't hold up any unnecessary time. All right. Draft committee report, negotiating mandate stage. Report of the Standing Committee on Finance, Economic Opportunities and Tourism on the Copyright Amendment Bill, B13D of 2017, NCOP S76, dated 11 May 2023, as follows. The Standing Committee on Finance, Economic Opportunities and Tourism, having considered the subject of the Copyright Amendment Bill, referred to it in terms of Standing Rule 217, confers the Western Cape's delegation in the NCOP the authority to not support the bill in its current form and calls for the bill to be redrafted in its entirety for the following reasons. Procedural issues, the first being a lack of availability of a socio-economic impact assessment, the absence of an impact assessment on affected industries, as per the article in Daily Maverick, was a significant oversight. This meant that we were legislating without a full understanding of the potential effects. The Department of Trade, Industry and Competition, formerly now DTI, conducted research on which to base its intellectual property policy favouring of fair use, but none of the studies provided by DTI contained contextual proposals for legislative amendments to the Copyright Act. DTI did not provide the final version of the Genesis Analytics report, which is not publicly available. If the Copyright Bill, the bill, is passed without proper consideration, its socioeconomic, without proper consideration, sorry, we're just scrolling a little bit too fast for my eyes to keep up. Its socioeconomic impact, legal action could be taken against the sub. I note, apologies, the hand of Member van der Westhuizen.
Yes, sorry, Chair. Would you like us to stop you when we pick up something which we would like to propose, or do you first want to go through the full document? Apologies for asking only now.
All right. Okay, members, if there are going to be a few amendments, perhaps what we can do is then we'll just pull up the page. We can go through it, have a look page by page, and then I can read it in. All right. So let's scroll up, please, Lizette, if that's in order. Okay, members, from the following page, if you can please peruse and let me know if you have any hands or comments. Member van der Westhuizen.
Thank you, Chair. Can I just say, we ask that it be redrafted, but then we go into procedural issues. So it's not only the redrafting, but it's actually the process that we're also addressing. And I was wondering if Lizette could just scroll up a little bit more and calls for the bill to be redrafted. Shall we? Or my proposal would be to say to be redrafted, and for me it's and undergo the full, can we call it, legislative process.
Legislative research.
Yeah, thank you. Because I think you get my point that, you know, it's not only for the wording to be, when I speak of redrafting, the image in my mind is that we only want the wording to be changed, but it's actually the full consultation, participation process of drafting bills that I think we believe was a bit circumvented or that some shortcuts were taken. Lizette has got captured what I had in mind, but I think your English is much better than mine, Chair.
I doubt that, but thank you. I think that's fine. Maybe after legislative process, I would say which includes public participation and a thorough social impact assessment, socioeconomic impact assessment. My English is failing me, member.
New chairperson, can you just repeat that last one?
And a full socio-economic impact assessment. Or perhaps instead of full, say comprehensive.
Thank you, Chair. Much appreciated.
Thank you. Right. And scroll down a bit more. Okay. Can just give it a minute for members to have a read through. Members, please put your hands up if you do spot anything. Or if we're going too fast. Okay. I think I can scroll. I note member van der Westhuizen has made a comment saying where we have just amended, I believe the words full drafting should move earlier in that sentence. Yeah, before in its entirety.
Yeah, sorry. So should we redraft it in its entirety and undergo?
Yeah.
For the following reasons. Thank you.
I'd like to propose that we also add this section to the section under performance protection, but we'll get there. And then we'll have to just, sorry, Lizette, if you can go up.
It's just an "it's" that should be removed as well. Deleted.
Yeah, so redrafted. We must remove "it's" and then yeah. And then that last bit, in its entirety, there's a duplication.
Should be redrafted in its entirety.
So the first, and then in that last entirety. Correct. So impact assessment for the following reasons, not impact assessment in entirety. There we go. Okay. We can scroll down to where we were before. Right. Those are just the different sections. Again, noting the socioeconomic impact. All right, happy. No comments? Again, no comments? No comments?
So according to the News 24 article, it would probably then also be prudent to give a link or a date, to that article so that people that read this would be able to get some more clarity as to what we are referring to.
There is a footnote for the article. So you'll see there's a little 3 at the end of the sentence.
Excellent, thanks.
Thank you. Okay. All right. And just remove rights in the Constitution. It looks like there's an additional space there. An unnecessary comma. Member Nkondlo?
Chair, if you go back to the News 24 article and the following section on the critique on the international, how do we choose which one, given that there has all equally been opposing references of the same in a different direction? So what makes the News 24 one more the one that the committee chooses, to substantiate and leave? I made reference as an example on the fair use by Dr. Nicholson, and I'm asking if we choose this particular reference to substantiate our point and ignore the other one, how do we explain that bias?
I wouldn't use the word bias. Essentially, this article supports the view that fair use could have unintended negative consequences in terms of job creation. But if we can just scroll up, please, in terms of where the footnote comes from. Yes, so this is used to substantiate the argument made that fair use could actually have negative impacts on the industry. And one of the main points that we've highlighted here today is that there hasn't actually been a proper socioeconomic impact assessment on the different industry or the different key stakeholders within the industry. So we don't really know whether they're going to benefit or not. And the current impact assessment is not clear in that regard. All right. Shall we continue? Okay. Members, any further thoughts with regards to the negotiating mandate or the draft negotiating mandate?
Can you allow us 2 minutes to read our minority view, Chair, if it's captured?
Yes, of course. Can I get an indication from,
Thank you.
thank you.
Yes,
Right.
our view is captured. Thanks.
Thank you. I see Zahida has very kindly as well included your remark on Dr. Nicholson as well. So we are a bit more balanced then. Okay. Members, with that, I'm going to read in the negotiating mandate. If there are no further inputs. All right.
Please go ahead, Chair.
Thank you. Committee report. Negotiating mandate stage. Report of the Standing Committee on Finance, Economic Opportunities and Tourism on the Copyright Amendment Bill, dated 11 May 2023, as follows. The Standing Committee on Finance, Economic Opportunities and Tourism, having considered the subject of the Copyright Amendment Bill, referred to it in terms of Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to not support the bill in its current form, and calls for the bill to be redrafted in its entirety and undergo the full legislative process, which includes public participation and comprehensive, if we can just add, and a comprehensive socio-economic impact assessment for the following reasons. Procedural issues, lack of availability of a socio-economic impact assessment, the absence of an impact assessment on affected industries, as per the article in Daily Maverick, was a significant oversight. This meant that we were legislating without a full understanding of the potential effects. The Department of Trade, Industry and Competition conducted research on which to base its intellectual property policy favoring fair use, but none of the studies provided by DTIC contained textual proposals for legislative amendments to the Copyright Act. DTIC did not provide the final version of the Genesis Analytics report, which is not publicly available. If the Copyright Amendment Bill, the bill, is passed without proper consideration of its socio-economic impact, legal action could be taken against the South African government. Socio-economic impact assessment systems, or the CS, which was only provided to the committee upon request and not shared with the public, further omitted crucial elements needed to reassure the industry. The CS analyzed effects of the proposed bill on a range of socio-economic factors. However, these assessments did not consider the impact of the bill on specific industries. We can scroll down. This was a significant limitation, as the impact of a bill on a particular industry could be vastly different from its impact on a broader economy, resulting in unintended consequences. Therefore, it was important for socio-economic impact assessments to take a detailed industry-specific approach to provide a more accurate and comprehensive understanding of the bill's impact. Poor drafting. The quality of the drafting of the bill was criticized for having a lack of clarity, having provisions that contradicted one another, being a patchwork of different provisions that have been hastily put together, and having been drafted without adequate consultation with stakeholders, including copyright owners, creators, and users. We can scroll down. Lack of public participation. The process of drafting the bill has lacked adequate public participation, leading to potential disparities in the perception and application of the law, as highlighted in Daily Maverick's article. The public participation process was criticized for lacking transparency, engagement, and inclusivity. These issues have raised concerns about the legitimacy of the bill and its ability to adequately address the needs and concerns of all stakeholders. Substantive issues, negative economic impact. We can scroll down. Without a proper socio-economic impact assessment, one cannot predict the bill's economic impact. However, the clauses relating to fair use and resale royalties, clauses 12A and 7C, may negatively impact creators and industries. I've cited clause 12A and clause 7C. We can scroll down. In 2019, The International Intellectual Property Alliance, IIPA, requested the US government to reconsider South Africa's trade access due to Copyright Amendment Bill, arguing it failed to provide adequate protection for US copyrighted works. This could cause South Africa to lose up to 16% of its exports, resulting in a loss of approximately 12 billion rand. A PricewaterhouseCoopers assessment found that the bill could cause a loss of 1,250 jobs in the publishing industry in South Africa alone. Retrospective and arbitrary deprivations of property. The bill has been criticised for having a retrospective application to copyright assigned before the new sections come into operation and may be unconstitutional on the grounds that they constitute an arbitrary deprivation of property under Section 25 of the Constitution. The bill also proposed to reduce the protection that a copyright owner has over their copyright by introducing new purposes for which the works may be used without constituting copyright infringement. Sections 12A and 12D would represent disproportionate and arbitrary deprivations of intellectual property rights. Section 12A is noted and Section 12D is noted as well. We'll then move on to proposed Section 19C3, which provides for a library, archive, museum, and gallery to provide temporary access to copyright work to a user or another library. It was not clear from this section what was meant by access. It was therefore submitted that proposed Section 19C needed to be reassessed. Section 19C3 is then referenced. Impermissible delegation of legislative power to the minister. The bill may provide an impermissible delegation of legislative power to the minister as it confers substantial discretionary powers on the minister without any oversight from the NCOP. The bill also includes a blanket contract override clause and grants the minister powers to lay down compulsory contract terms limiting the freedom to contract, which is unworkable. The bill grants extensive powers to the minister in sections such as Clause 7B, which could lead to arbitrary and subjective decision-making. Section 7B is then referenced. Negative impact of fair use, resale royalties, and copyright exceptions. As per the cited News 24 article, these provisions could significantly disadvantage creators, providing too broad exceptions and potentially undermining the incentive to create. The introduction of fair use could result in an overly broad interpretation of what constituted fair use, which could lead to copyright infringement, making it difficult for copyright holders to enforce their rights. The bill's introduction of resale royalties for visual artists could discourage investment in the art industry, leading to a decrease in revenue. The bill's introduction of copyright exceptions could lead to infringement of copyrighted works without the necessary compensation to the copyright holder. We can scroll. Lack of adherence with international treaties. The bill has been criticised for failing to adhere to international treaties, which could have implications for South Africa's international trade relationships. The bill may also result in a loss of foreign investment to South Africa's creative industries. Section 12A introduces the principle of fair use, which is contrary to South African law. Fair use is also not widely used as an approach globally, and it does not comply with the three-step test set out in the Berne Convention and the TRIPS Agreement. Section 12 would breach these conventions and would be unconstitutional. General concerns and proposed amendments. The definition of orphan work should add the word cannot reasonably be identified. The risks of the amendments on the industry should have been studied by means of a socio-economic impact assessment or study. The bill is too prescriptive in terms of the contents of agreements between parties, the fixing of prescribed royalties, among others. This seems to remove some freedoms under the Bill of Rights in the Constitution and may result in this bill being successfully challenged in the relevant court. The fact that the bill refers to Intellectual Property Laws Amendment Act which has still not been signed off by the President, is problematic for the implementation of this bill should it be adopted. Section 7 refers to 1. Royalties on resale, 2. Payable at the rate prescribed, 3. The seller and art market professional concerned are jointly and severely liable to pay royalties to the author or their heirs. All allows too little scope for unique circumstances, such as when the seller may be the artist him or herself. Clause 9, dealing with Section 8A. This section should be scrapped and relevant amendments made to 6A. Furthermore, Section 8A 6A requires that it be proved that someone intentionally failed to register an act as per 5A and 5B. This is problematic in its application. As speed is important and action should be taken soon, how will one be able to determine what year was the year in which the majority of offences were committed, if A, the offences were not yet found to be offences, and if the trend of offending could still be on the increase? The DTIC has not adequately addressed these issues, necessitating a comprehensive redrafting of the entire bill. We can scroll down. Minority view. In terms of Standing Rule 90, the African National Congress expressed its minority view to support the bill, but asked that DTIC affect the concerns raised by stakeholders during public participation, which included disappointment raised in respect of delays in the legislative process with new committees and demonstration of a lack of familiarity with complexities of the bill nor its urgency, quoted from such a submission. Furthermore, consideration should be given to other submissions made at public hearings, such as Dennis Nicholson from Scholarly Horizons, who raised the concern of ample scientific evidence made that include studies on the evolution of fair use. Ms. Nicholson advised that on appreciating the real benefits of fair use and claimed that it is a permit to increase access to knowledge for all South Africans. In terms of Standing Rule 90, Al-Jamaa expressed its minority view to support the bill, requesting that consideration be given to concerns raised by stakeholders during the public participation process. Members, with that, if I can please get an indication of whether you would like to adopt the negotiating mandate on the copyright bill.
Chair.
Member van der Westhuizen?
I want to propose that we adopt this report, but I also would like to put on, well, not necessarily put on record, think we could give Ms. Kruter the leeway to perhaps just add a few of the relevant sections of, or references to sections of the bill in this document, just perhaps to make it slightly clearer for those that need to work with this going forward. But my proposal is that we adopt this report as presented to us. Thank you.
Thank you. Were there any provisions that you wanted to add in particular, or any sections you wanted to add in particular?
Chair, it's only the references to some of the these sections. I don't know if Ms. Kluter would like to scroll down. There's an area, I think some of the paragraphs are marked with bullets, but perhaps if you could scroll down a little bit more, Ms. Kluter. I believe there was a section where it changed to letters of the alphabet, if I'm not mistaken. If you go down a little bit more. I think you're getting close now. Can I say there where the bullet points have changed into letters of the alphabet, there under G, for example, G refers to the proposed new 8A6C. 8A6C, that is, you know, the 8A, that is the insertion, a proposed insertion in the existing legislation. It is under section 9 on the on this bill itself.
Okay.
Well, that's just, I think it will just make it slightly clearer to those that want to know, to what sections are we referring to, if we can put those references, add those references. Thank you. But that doesn't change any of the content. Thank you.
Thank you. Member Nkondlo?
Chair, I noticed, and my apologies if I noticed this a bit late. I noticed that my last comment about the CMOs has not been included in the submission. Is there a reason for that?
That must be an oversight. Can we add that, please? Is it?
Will do. I'm just returning to the chat. Member through you, Chairperson, Member Nkondlo, is this what you're referring to? We will just refine it, but I just want to make sure that this is what you wanted to include with regards to the CMOs.
Yes, Lizette.
Thank you. Can we get a seconder to adopt this?
Seconded.
Seconded, thank you. Okay, thank you very much. So we'll now move on to considering the draft negotiating mandate for the Performance Protection Bill. Lizette, if I could ask you to please flash that again. Then I think what we will do is we'll just go through the negotiating mandate, scroll through it, see if there's anything missing, and then we can read it in and resolve. I do see two hands. I just want to check if they are legacy hands. Member Nkondlo? Member Seleko?
Legacy hand, Chair, my apologies.
Okay. Right. So here we have the draft negotiating mandate for the Performance Protection Bill. I think I just want to check in terms of my first edit that we have the same amendment we had to the first bill, that being that it followed the legislative process, including consultative processes and research processes. I think we can just copy what was written in the copyright bill and then add it there. Yep. So quick read of that. Okay, that's great. Let me scroll down. Members, please jump in if you'd like to add anything or raise your hand. All right. So we scroll down. Okay. Okay. Right, members, and then that brings us to the minority view. Right, are there any comments with regards to the negotiating mandate? Member van der Westhuizen?
Yeah, I propose that we adopt this report.
Thank you. I'll just read it in quickly, but I just want to make sure that we're all happy with the contents before. Okay. Everybody's very quiet, so I'm going to read. Committee report, negotiating mandate stage, report of the Standing Committee on Finance, Economic Opportunities and Tourism on the Performance Protection Amendment Bill, dated 11 May 2023, as follows. The Standing Committee on Finance, Economic Opportunities and Tourism, having considered the subject of the Performance Protection Amendment Bill, refer to it in terms of Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to not support the bill in its current form, and calls for the bill to be redrafted in its entirety and undergo the full legislative process, which includes public participation and a comprehensive socio-economic impact assessment for the following reasons. Procedural issues. Poor drafting. The bill was criticised for having been poorly drafted, and its contents were often conflated with what was included in the Copyright Amendment Bill. Clauses 1 to 32 of the Performance Protection Amendment Bill contain provisions that overlap with and/or duplicate existing provisions in the Copyright Act. This lack of clarity and overlap between the two bills makes the Performance Protection Bill confusing and problematic. This bill is unclear in various sections, leading to potential misinterpretations and inconsistencies. For example, Clause 5 regarding equitable remuneration lacks specific guidelines. Clause 5 is cited. We can scroll down. Lack of availability of a socio-economic impact assessment. As with the Copyright Amendment Bill, this bill lacks an impact assessment on affected industries, leading to potential unforeseen consequences. The bill was introduced without proper socio-economic impact assessment, which is necessary to determine how various stakeholders within the industry, including film, theatre, design, and music, could be adversely affected. The socio-economic impact assessment system, or CS, which was only provided to committee upon request and not shared with the public, further omits crucial elements needed to reassure the industry. The CS analysis, the effects of the CS analyzes, apologies, that is a spelling error there. Should be analyzes. The effects of the proposed bill on a range of socioeconomic factors. However, these assessments did not consider the impact of the bill on specific industries. This is a significant limitation, as the impact of a bill on a particular industry may be vastly different from its impact on the broader economy, resulting in unintended consequences. Therefore, it is important for socioeconomic impact assessments to take a detailed industry-specific approach to provide a more accurate and comprehensive understanding of the bill's impact. We'll then move to substantive issues. Negative implication on international treaties, if we can just amend treaty to treaties. The bill could contravene international copyright law, potentially causing diplomatic complications and harming our creative industries. The bill violates international treaties because the existing act is not aligned with the Rome Convention, and the proposed amendment may exclude performances protected under international treaties. The definition of performer in section 1H should include extras in line with the Beijing Audiovisual Performances Treaty and international standard practice. Section 1H is cited. Undermining freedom to contract. The bill potentially limits freedom to contract between performers and producers. A prescriptive approach to contract regulation may not be suitable for all creative talents and producers across different copyright industries. Limiting freedom of contract could discourage investment in creative industries and reduce opportunities for performers. The bill, in its current state, undermines the freedom to contract, creating potential for abuses and unfair treatment as illustrated in Clause 8. Clause 8 is cited. Confusion between performers' rights and copyright. The bill blurs the line between performers' rights and copyright as seen in Clause 3, leading to uncertainty about ownership and compensation for exclusive rights and remunerative rights. Clause 3A is cited and it refers to transfer of rights. Clause B is cited, which refers to protection of rights of producers of sound recordings. The proposed changes may blur the distinction between performers' rights and copyright, leading to uncertainty about ownership and compensation. This confusion could lead to disputes and legal challenges, making it difficult for performers and producers to enforce their rights. Section 8A could be deleted from the Copyright Amendment Bill and exclusively dealt with in this bill to avoid overlap and confusion. The DTIC has not adequately addressed these issues, necessitating a comprehensive redrafting of the entire bill. Minority view. In terms of Standing Rule 90, the African National Congress expressed its minority view to support the bill, requesting that consideration be given to technical amendments and comments proposed by stakeholders during the public participation process that would improve certain clauses. In terms of Standing Rule 90, Al-Jamaa expressed its minority view to support the bill as well. Members, with that, I would now like to open up. If we could please get an indication of whether this negotiating mandate is supported or not. I recognize Member van der Westhuizen.
Again, I just want to reiterate, I propose that we adopt this report.
Thank you. I recognize Member Seleko.
Thank you, Honourable Chair. I will definitely support second the proposal from Honourable van der Westhuizen. Thank you very much.
Thank you. I do see a hand from Member Nkondlo.
Chair, before I support the report, can I request that the same comments we made in the copyright bill be put in this one, as it's done with the other content. With that, then I would support the report. So the same comments we made, and if they could be copied and pasted here.
Does that relate to the CMO, or I just want to make sure that we're not confusing the contents of the two bills?
We're not.
Okay.
We're really not. Thanks.
Lizette, okay, thank you. Lizette, could you copy that over and then we can just have a look over it?
Okay, through you, Chairperson, Member Nkondlo wants me to include the CMO matter in this mandate as well, because I'm just going through the comments and seeing which bill Member Nkondlo is referring to in the chat.
I think Member Nkondlo indicated she would like the entire comment she submitted for the previous bill to also be put into this bill.
Okay, I'll just copy and paste from the previous one and I'll update it now. I'll just have to read this again that it makes sense and then just look at the comment of Denise Nicholson because I'm not even sure. Member Nkondlo can maybe just indicate what she wants included. I basically pasted the previous reports input.
Over to you, Member Nkondlo.
Yes, Chair. I'm not sure what could be the challenge there. I requested that the comment that I've made in the previous bill be included here. Because as we said, and if you look at our comments, they are more generalized. And I think the issues of fair use are actually found in both because there is a direct correlation between the two. So that is why I'm requesting that in both bills, our comment is the same. That's all that I'm requesting. Thanks.
Okay, cool. So you're happy then, member, if we just copy and paste and proceed?
That's what I asked. Thanks, Chair.
Thank you. Better to be on the same page.
We'll
all right.
just have to just redraft it so that it's included as requested.
Okay. Members, any final points before we move on? Noting that we have now adopted the negotiating mandate for performance protection. All right. With that, we will now have the opportunity to make any resolutions. Members, can I get an indication of whether there are any resolutions resulting from today? I see none. I'd just like to inform you that we still need to confirm our date. I see Member van der Westhuizen.
Sorry, Chair, you were a bit quick for me. Can I just say, I first would like us to express our gratitude towards the public for the participation. I must be honest, it's long been, I don't know if I've ever been involved with bills that solicited so much, so many inputs, etc. The second one is also our gratitude towards the staff for arranging all those public participation events, for summarizing the input in tabular form, etc. It must have been quite a huge task for them, and congratulations on behalf of the committee to them for a task well done. And then also, Chair, to you, who kept everything together. I really think it was that was perhaps a bit of a vuurdoop for you, but I think you did exceptionally well in assisting us to get to this point. Thank you very much.
Thank you very much, Member.
May I also just, perhaps I should have started with this, just that we put on record that, you know, while we are not supporting these bills, we really believe that a revision of this legislation is long overdue. I think Honourable Nkondlo has also stated that. I've said it earlier, but I think if we could include that under our resolutions, it is only that, you know, we believe that unfortunately this round has not ticked all the boxes or met all the expectations. Thank you.
Definitely, thank you. Member Nkondlo?
Thank you, Chair. Whilst I have a different view with what member, I think the spirit of not, putting legislation as a measure to sort of, impose our different political views on matters, which is what I think you would also have related to, I think becomes important, because indeed this is a bill that is very important in the reforms of an old system that must then help a new dispensation and help our local artists. Having said that, Chair, I would wish to inquire or be advised of what process will the social impact assessment that we received from DTIC can actually be shared, since we did indicate that we are asking it for many that have not seen it. If those can be enlisted
And further, we can have, through our public outreach office, circulate that economic impact assessment so that whilst we, through the committee majority view, argue that the whole process must be restarted, that information is shared, one. Number two is to inquire the extent to which our own economic development department can actually further run awareness, because one takes from the public hearings, from the one we held, I think, in the Garden Route, right to the last one in Cape Town, there is a fair amount of interest, particularly amongst young people and those that are still at a very initial stages, in as far as, enterprising their knowledge in terms of youth and others, whether there could be workshops to explain what copyright is, in relation to their understanding. So I'm placing that inquiry, if the committee would be able to make that request to the department, the Provincial Department of Economic Development, because that, I think, is very important for the actual stakeholders, especially those that are at the lowest ladder, to understand what copyright means to them, so that when they participate in these legislative processes, they are able on their own to have views that are informed based on the knowledge that they've acquired. Thanks, Chair.
Thank you. I might add that I think the Department of Economic Opportunities can play a supporting role, but my request would rather be that it comes from or be led by DTI as the custodians of the bill. But I do agree that a workshop on that would be extremely helpful. Then can I just confirm before we proceed, we did actually request and receive the CS report. Ms. Adams, did we circulate that with members? If not, can that be circulated with members?
Yes, members. Chairperson, it has been circulated.
Thank you. Okay. Just to note, members, the CS report was requested and circulated among members, but the other notes and resolutions were made. All right. If there are no further resolutions, then I would just like to inform members that our date for our final mandate is tentative. We are looking at the 26th of May. Then I'd just like to echo Member van der Westhuizen in sincerely thanking everybody who's been a part of this very rigorous process. Thank you to all the members. I know that it's been very difficult, a lot of traveling. We have had to really apply our minds to quite difficult subject matter. And so thank you for all of the time and effort that you've put into this. Thank you to all of the support staff, and a big thank you to Ms. Adams for taking us through this process and making it all possible. Definitely couldn't have gotten through this without each and every single one of you. And sincerely thank you to all of the members of the public. It can be very difficult to relay to you how much we appreciate your inputs. And I think sometimes it can feel as if submitting your inputs goes into a void. But that's our job to make sure that it doesn't, and that we try to represent you as best as we possibly can. And so thank you for taking the time to indulge us and to look at this difficult legislation as well. With that, members, I would now like to adjourn. Thank you.
Thank you, Chair.
Thank you, Chair. See you later.
Oh, I forgot to say have a safe